Hi, this is Mary Beth Gettins with a case analysis. When folks enter into agreement, there is usually a faith that the other party will act fairly. This faith of fairness is often not spoken, but implied. When a conflict arises, it is commonly said, "That is not fair. It's not right. We entered into this agreement, and I never envisioned this." In the legal world, this faith that the other party will act fairly is referred to as an implied duty of good faith and fair dealing. Claims for breach of good faith and fair dealing are fairly common in the franchising industry. A franchisor commences an initiative or takes an action against a franchisee. The franchisee views the initiative or action as adversive, unfair, and not something that was ever contemplated. That is the case of AMTX Hotel Corporation versus Holiday Hospitality Franchising Inc. AMX expended $2 million in renovations and remodeling and another $200,000 to comply with relaunching in anticipation of renewing their Holiday Inn franchise agreement. Under the 2006 franchise agreement, AMTX franchise was not entitled to renewal, and they acknowledged that. However, Holiday Inn promised and represented that AMTX franchise agreement would in fact be renewed if AMTX was in compliance with the franchise agreement, and they also stated that no other full-service Holiday Inns were going to be licensed in Amarillo, Texas. Holiday Inn, however, did not renew AMTX's franchise agreement. Instead, they licensed another in Amarillo, Texas. AMTX claimed promissory estoppel and breach of good faith and fair dealing. A Georgia court sided with Holiday Inn. Promissory estoppel is just what it sounds like. You are stopped from doing something because you promised. The court found that Holiday Inn's representations and promises were not enough to overcome the written language of the franchise agreement. The franchise agreement said you have no right to renew. Therefore, they had no right to renew. The court went on to say Georgia law does not recognize an independent claim of good faith and fair dealing. In Georgia, you have to point to an actual provision in the contract and affirmatively show that the other party breached that provision. It is not enough to say, "I thought it was implied that you would act fairly and in good faith."